Good afternoon, everybody. Today is Monday, April 5th. It is 9 a.m. Pacific, noon Eastern. You will hear the church bells chiming behind me, the noon church bells, if you can. This is our monthly California call. And joining me on today's call is the venerable Chuck Michele and his band of merry men, although I only see one merry man, Josh from the Dale. I don't see any other Matt Cubiero type merry men. Also joining us are brother Brian from Client Relations fame, and welcoming back Hank Yasek, who we missed last month, but he has now returned. Big things happening. Oh, there's Matt. So now the merry men, Chuck's merry men, are all here. And as I often do, I merely say hello and move it on to Chuck, Josh, and Matt. Fire away, boys. What do you got for us in California? Oh, wait, one more thing. The symposium. The symposium is coming. Please go through the clients only website. Sign up. You get the law and compliance component of the symposium, the virtual FFLGuard symposium for free. So sign up there and then buy into the business and firearms technology tracks. But please go do that when you can. And Chuck and the boys will have a whole California dreaming section at the symposium. So have at it, Chuck. What do you got?
Well, I'll let Matt go first, and then I'm pretty much going to say what I said on the federal call again, if that's okay.
Yeah, whatever you like.
Okay, so can everyone hear me okay? Am I coming through good? Yes?
Yep,
no?
Yep. You're there.
Cool. It's been a relatively quiet month as far as DOJ regulatory compliance issues are concerned. We did get a question recently regarding dangerous weapons permits. We've been hearing and we've been seeing DOJ has been issuing extension letters for individuals with dangerous weapons permits because they're unable to process them in a timely fashion. When I say they, I mean DOJ is unable to process the applications in a timely fashion, of course, surprise, surprise. And so instead what DOJ is doing is they are issuing letters to dealers with dangerous weapons permits to notify them that just basically saying, you know, we understand you submitted your application on time, you're good to go. Just know we haven't actually processed the renewal yet. So as long as you have that letter that covers the current time period, you should be fine as far as licensing issues are concerned. So just be aware of that. It is also possible that DOJ would issue something similar to dealers for purposes of general licensing, like their actual California firearm dealer's license, things like that. I haven't seen that actually happen yet, but it is possible. So just be aware that, of course, DOJ being what it is and everything that's going on from a regulatory standpoint, that they are unable to basically process applications in a timely fashion. Of course, we've been harping on this with COEs, so it's now obviously extending into other licensing issues as well. So just be aware of that. Let us know if you have any questions, and we can try and assist you guys with that. Chuck, were you wanting to talk about the Young case? I'm assuming that's what you were going to talk about.
Yeah.
Yep. Okay. So that's all I have from a regulatory standpoint. If you want to talk that, Chuck.
Yeah. Okay. So just digging out my notes from the last call. So we got an opinion of the Ninth Circuit en banc, and for those of you who haven't followed this procedurally since the Peruta case and some others, en banc review means you go from the district court with one trial court judge to the Ninth Circuit 3-judge panel. That's your first level of appeal in a federal court. If a larger section of the judges, there's roughly 25 on the Ninth Circuit, doesn't like the ruling from that 3-judge panel, they can do what's called an en banc review, where 11 judges are selected from the Ninth Circuit to review the 3-judge panel ruling and decide whether they agree with it or not. That recently happened in the Young case, which challenges the public carry ban in the state of Hawaii. Just going to move this. That recently happened in the Young case because they had won it at the 3-judge level, thanks to the fact that you had Judge O'Scanlan on that 3-judge panel. Those of you who remember the Peruta case from a few years back, that was a CRPA in our case, challenged California's statute, basically good cause requirement, saying you need to demonstrate some special need in order to get the privilege of a license to carry a firearm in public. We won in the Ninth Circuit because Judge O'Scanlan was on that court, got it, wrote a great opinion, and then that case was taken primarily at the prompting of then Chief Justice Sidney Thomas, who unfortunately replaced Libertarian Justice Kaczynski, who got stung by the Me Too movement. And he is very anti-gun, even though he's from Montana. So he took Peruta en banc and overturned the opinion, and in the process played a lot of games and said, well, what you're saying is that there's a Second Amendment guarantees a right to carry concealed. Well, that's not what we said. We said it guarantees a right to carry either concealed or openly, that the legislature can regulate the manner, but they can't ban it entirely, and requiring a special need to show good cause bans it entirely. And that's what Justice O'Scanlan agreed with. And that's what Justice Thomas then went out of his way in the en banc opinion to overturn. So that opened the rather obvious question of whether or not, if there's no right to carry concealed, is there right to carry openly? And as is apt to happen, unfortunately, when lawyers, even frankly underfunded, under-resourced, and unqualified lawyers, see that that's the kind of the open question, that there's this open question that the court's going to have to answer at some point, then they rush to file a lawsuit so they can be the ones that push the issue. And that's what happened in Young, that they wanted to push this issue, and they did, and then they got their ass handed to them, which may very well have happened anyway, but there was a whole lot of things that they could have done to increase the odds of success, or at least limit the damage that was going to be done, but they didn't. And now we've got a 127-page bashing of the right to public carry. The upside of that is that it exacerbates the split among the circuits on whether or not there is a right to carry in public. And that really is going to need to be resolved by the Supreme Court. Fortunately, there is a case pending in the United States Supreme Court right now, the New York State Rifle and Pistol Association versus State of New York case, about New York's requirement that you demonstrate a special need to establish good cause in order to be able to carry a firearm in public. And if you'll recall from the last Supreme Court session, at the end of the session, there were like 11 cases, Second Amendment cases, all waiting for a decision on whether or not the Supreme Court was going to grant cert and review the losses in the lower courts. And it denied cert in all 11 cases in one sweeping order. That was before Judge Barrett was on the court. And everybody speculated that even though Justice Kennedy was gone, Justice Roberts did not have the stomach, the political stomach, to take one of those cases on. We got scathing dissents from Justice Thomas, who says you can't keep running away from a ruling on the Second Amendment. The courts are thumbing their nose at Heller and McDonald. You have to set the record straight. But remember, it takes 4 votes to accept the case for review and 5 votes to win. So if the judges know that they don't have that 5th vote, usually they won't, the 4 that could vote to accept it won't vote to accept it because they know they're going to lose. That's what Justice Scalia did for us for years. In any event, this New York State Rifle and Pistol case was pending, but not in the Supreme Court when the Supreme Court turned down review in the 11 cases last year. So it is now back in this, it is now in the Supreme Court. And we have a new Supreme Court justice, which should give us a solid 5-vote majority, and maybe even 6 if we pick up Roberts, to take that case. Now, the Supreme Court holds conferences every week or so private conferences among the justices to decide which cases to take. Last week they had the second conference on whether or not to take the New York State Rifle and Pistol Association case. Typically what happens is they have a conference on Thursday or Friday. On Monday, they issue an order that says the cert is granted or cert is denied. We take the case or we don't. They had a conference last week. There was nothing in the orders from today that said they will or will not take the New York State case. So we have to wait, see if they have another conference. They have conferences generally so the judges can argue with each other about whether they should take a case. And typically what happens is if they're going to take a case, they will have one or two conferences before they announce that they're granting cert and taking a case. If they're not going to take a case, they'll have 3 or 4 or 5 conferences because typically if you have more than one conference and they're not going to take a case, it's because one of the justices is writing a dissent, once again, criticizing his colleagues for not taking the case. And that's what Justice Thomas did last time around on the New York public carry case, the New Jersey public carry case, which was one of those 11. And the public carry cases are the ones where there's the most pronounced split amongst the circuits. So that's typically a test. That's typically a factor that makes the Supreme Court grant review. So we don't know for sure which one it is, obviously. We're reading tea leaves to an extent here. But either they're going to grant cert probably next week, or they'll postpone it a few more times while Justice Thomas writes another dissent, and whoever else joins with him dissents saying that they should have accepted the case for review. And then if that's the case, unfortunately, the Young case will probably be the next case that asks the Supreme Court to grant cert. And that's, I don't know, but that's not the ideal vehicle, and they're not the best lawyers. They've been offered now to have Paul Clement and Kirkland and Ellis step in for free and brief and argue the case in the Supreme Court, because the lawyers that are on that case are not good enough, frankly. They don't have the resources or the time. You got to shut your practice down for 3 months to be ready to go argue a Supreme Court case, is the general rule. But hopefully they will, if it comes to that, they will let Clement step in and do the argument. You really need to be a Supreme Court specialist in order to argue a Supreme Court case and maximize the chances of winning. They make movies about the people who aren't and win. And the reason they make the movies is because it doesn't happen very often. It's very rare. That was the Larry Flint Hustler magazine versus Falwell case, which wasn't as big of a win as it was made out to be in the movies. But anyway, point is, New York State Rifle Pistol pending, Young backed up behind it, and Duncan also is another case. This is the 3-judge panel struck down the ruling, or struck down the law that banned the possession or importation of magazines that can hold over 10 rounds. Another great win for CRPA. And now, of course, Thomas wants to take that en banc. And we'll see what happens, because the composition of the Ninth Circuit has changed a lot, because Trump appointed a bunch of judges to the Ninth Circuit panel. So it's now almost 50-50, maybe a little bit more even, on the conservative side, rather than what it used to be, which was 2/3 liberal progressives and 1/3. So the odds were always against you. Now the odds are roughly even. So we could get a panel in Duncan that is actually weighted in our favor. We'll have to wait and see. So the good news about that is yesterday, 22 attorney generals from states across the country filed an amicus brief, a friend of the court brief, saying that this ban on standard capacity magazines should be struck down. The lower court, the 3-judge panel's opinion, should be upheld. That's pretty heavy duty. So it's getting a lot of national attention. And again, we'll have to see what happens. We're briefing it for the en banc panel. We got a lot of amicus support. And now we'll see what kind of panel we draw for the 11 judges. If we get a loser panel, that's the next case that could be taken to the United States Supreme Court. The other thing I wanted to make sure you guys were kind of up to date on is the precursor receiver, the so-called 80% receiver issues. This is, you know, they love those emotion-laden buzzwords, assault weapons, Saturday night specials, and now ghost guns. These are this is the latest campaign that every town and all the usual suspects, San Francisco, Los Angeles, are all piling on to try and ban precursor receivers, 80% receivers. And they have filed unfair business practice actions. They have filed, the ATF is doing investigations. They've filed personal injury lawsuits naming the makers of these products. The first important distinction to keep in mind is that even the ATF says that the precursor lowers are not firearms. The only things that they are saying are firearms are the kits, where you have the jig and all the parts, and it's all in one box. And frankly, my opinion, that was pushing the envelope, asking for trouble, but they sold a lot of them. And now the ATF wants to deem that kit to be a firearm. So it's becoming an argument about regulatory deference, whether or not the ATF is as a regulatory agency responsible for enforcing these laws, should be given any credence in what their interpretations are of what is and what is not a firearm, interpreting the law. And that's a bigger debate that they're having in the context of lots of different regulatory agencies. Often the Environmental Protection Agency gets this. It's called Chevron deference, where the courts are inclined to defer to the interpretation of the regulatory agency. We've run up against that with DOJ, California DOJ as well. That's a doctrine that is finding more disfavor of late. And most recently that came out in the lawsuit challenging the bump stock as a machine gun. And the ATF basically changed their opinion on that for political reasons, declared that the bump stock was a machine gun after the Las Vegas shootings. And recently, last week, a court said, no, the bump stock does not meet the definition of machine gun, and it isn't one. So that's the kind of thing that's going on. It's this agency interpretation and whether it gets any deference. But again, for your purposes, it's the kits that you have to be concerned about. I don't know if anybody's having anything to do with the non-firearm precursor receivers or not, but I thought it'd be something you should know about. The last thing is I wanted to make sure everybody knows we have launched the Second Amendment Law Center with NRA in bankruptcy and their funding severely limited. They have cut off support for a lot of lawsuits and a lot of programs, not just in California, but all across the country. A lot of the lawyers that used to be doing a lot of work for the NRA, including everybody at my firm, but also Chris Chiafullo is on the advisory board, the legal team for the Second Amendment Law Center, Steve Hallbrook, a whole bunch of other folks. You can see it all at 2alc.org, Second Amendment 2alc.org. That basically it's what I consider the A team of Second Amendment lawyers coming together to step in where the NRA is now dropping the ball. And so I'd ask folks, do whatever you can to support or promote or let people know about that effort, because when, and I say when, not if, the Supreme Court issues a ruling on the Second Amendment, I expect that with Barrett on there, we will have a majority, and we will get a Second Amendment. We'll get back a Second Amendment with some teeth, and then we can go after a whole bunch of laws, not just in California but all across the country, that can't be justified, that the legislature cannot provide evidence that show they work, and that unnecessarily infringe on the right to keep and bear arms. So We need to build up a war chest there. By the way, everybody on that legal team is not being paid. I am not being paid to participate in that. No one's going to be paid unless and until we actually file a lawsuit where they're doing the heavy lifting of filing briefs and such. And even then, it'll be at a discounted rate. So this is not about money. It's about getting the legal precedent, impact litigation to protect our rights, from whoever comes from Kamala Harris. If Biden drops out, she's going to be even worse. But there's a whole, obviously, segment of politicians that just want to do away with the Second Amendment entirely. And so we've got to try and put a stop to that. I think that's all I've got.
And how about the handsome Joshua Robert Dale down there?
Glad you're finally recognizing that, Brian. I'm
wondering,
wondering.
do you have a mullet too? Are you part
No,
of?
no, I don't. I'm working on
the front,
it. I'm
party
working
in the back.
on it.
All right.
No, the summer mullet usually takes a couple months to grow in, so I'm working on that. I'm tuning up my Trans Am. I'm getting ready for summer. We all are at MAPC, so we're very excited about it. I want to circle back on something Matt was talking about, which are structural issues with the California DOJ, and just add a little personal anecdote. For many years, I've had an FFL3 collector's license, and in conjunction with that, to utilize all the rights and goodies of having an FFL3, if you're in California, you have to go out and get a certificate of eligibility. This year, for the first year, my certificate of eligibility got delayed through the California DOJ, and the main reason was they wanted to now know my FFL3 license number, which is something they've never asked and which is not in the regulations. But as Matt and I both discussed offline, this is very endemic of what he was describing with regard to dangerous weapons permits, which is the DOJ is very understaffed. They have people in there now who don't really know what they're doing, and in some instances are doing some very odd things. So as you folks are applying for your COEs for your employees, as you're trying to renew dangerous weapons permits, this is something that's going to continue to go on probably for years and years and years. And so it's something that certainly Matt and other folks on our team are going to be focused on in trying to remedy and try to come up with stop gaps and then more permanent fixes, because from everything we're hearing from our contacts within the California DOJ, there is neither the money nor the support to really fix any of this stuff, and there aren't really any plans to do so. And as Chuck mentioned, now that Kamala has moved on to national prominence, and there are probably even less of a focus with Javier Becerra moving on. The mandate to the DOJ to do its various tasks, including apps raids and stuff, that's sort of all fallen by the wayside, and with it, some of the funding. So, this is something that, as you guys who are YSP members and FFLGuard members need help through the help desk on this stuff, that's part of the reason we're here. So one of the interesting things that has popped its head up recently with a few of our clients are the ADA mask cards. And this was something that happened very early on in the pandemic. We probably saw it over the spring and summer of 2020. And this was where if you were operating a retail shop and you had been given permission to reopen on a limited basis, you saw folks showing up saying, I don't want to wear a mask inside your store. And they would show you a little card, and it would talk about how under the ADA, they have a disability with wearing a mask, and they have a right to go into your store without wearing a mask. And if you don't do it, you could be subject to up to $75,000 in fines under the ADA. Well, this was the brainchild of several people, including a group that started a website called the Freedom to Breathe Agency. And they created a logo, and they created this little card you could print out. And it was quite the interesting response among many to people adjusting to the pandemic. And so initially when this happened, we were getting questions from clients about, well, what do I do when I get one of these? I don't want to get tagged with an ADA lawsuit. And the bottom line then, and it continues to be as this thing has now cycled through and apparently is on its second life, the answer is you don't have to do anything in response to those cards, because most of California is still under red or orange tier, and even under yellow tier. You still don't have to allow people into your store with masks. And in fact, if you look at both the California Department of Public Health and your local county health orders, they're still going to mandate masks, both as an employee safety issue as well as a general public safety issue. So the bottom line is, if you get one of these nutters with one of these cards who shows up and says, you got to do this, you got to let me in, the only thing that you have to rely upon in terms of making that decision is a doctor's note. So if you get somebody who comes in with a doctor's note that says that due to some disability, and they may not identify it, but due to some disability, this person does not have to wear a mask, then at that point, you as a retailer have to make a decision about whether you're going to let them in. And you can still insist on certain requirements, like they wear a face shield, one of those, poker style face shields with the stuff over it. If they claim they can't do that, you can offer an alternative accommodation of having a personal shopper do their shopping for them in lieu of letting them in the store. Our recommendation is, given how stringent the requirements are, particularly the Cal OSHA requirements for employee safety, that even if you're presented with a note, that you find an alternative way to accommodate them besides letting them in the store unmasked, because there's just too many pitfalls for you as an employer. If you have a bunch of employees who see an unmasked customer going through the store, you're opening yourselves up to lots of folks potentially going out on sick leave, potential OSHA violations. You do not want to really take on the burden of trying to justify and explain and defend yourself from the outcome of a customer who's going through the store without a mask with your blessing. So again, if you see one of these nutty little cards from the Freedom to Breathe Agency or one of its variants, you do not have to honor it. You can ask for a doctor's note, and the bottom line is, otherwise turn them away. So another issue that's been coming up is that now we're seeing more widespread vaccination availability. One of the questions we're getting from our employment clients is, what do I have to require my employees to get the vaccine? And conversely, can I refuse to allow an employee who refuses to get vaccinated to come back to work? And the general answer is that you as an employer have the right to refuse to allow an employee who refuses to get vaccinated to come back to work, unless, and here's the big unless, they have a bona fide religious or medical accommodation issue that allows them to refuse vaccination. So let me kind of unpack a few of these things. Going back to my first question is, do I have to require my employees to get vaccines? The answer to that is no, except that, again, if we go back to those Cal OSHA regulations that are very stringent, if you as an employer are saying, no, you don't have to get a vaccine, you are subjecting yourself to liability under workers' comp, potential liability to your customers. And part of that liability will be predicated on the fact that your COVID plan did not include making sure that your employees were vaccinated when they could be. So as a general rule, I would not take a position as an employer that you don't have to be vaccinated at some point to come back to work. Now, obviously, it's based on availability. So you're not going to have all your employees vaccinated now, but I would not adopt any kind of blanket policy that they don't have to be vaccinated if they get the opportunity to do so. So that's the first issue. The second issue is, okay, well, what if I have an employee that refuses to be vaccinated? And again, you don't have to allow them to work. And there's been a lot of debate over that recently, but the bottom line is the same vaccination rules that applied pre-COVID to other diseases apply to COVID, which is essentially you can require that vaccination. There's only a couple of religious groups that I'm aware of where they could assert a bona fide objection to receiving the COVID vaccination, and that would be the Religious Science Group and the Jehovah's Witness Group. I'm not aware of any other major religious adherents who'd be able to come in and say, I have a religious objection to vaccination. So absent that sort of bona fide identification of a religious belief, you can require your employees to be vaccinated. The other issue is medical accommodation. And this is just like the issue with the customers who refuse to mask. If you have an employee who says that for a medical reason they can't get a vaccination, then you can request a doctor's note. And the doctor's note isn't going to necessarily tell you the reason why they can't get a vaccination, but if they have a legitimate medical condition, then a doctor's note would be sufficient to excuse them from getting vaccinated. So just bear that in mind as you are trying to navigate your way through having employees come back, having employees be vaccinated, and dealing with whatever happens as we learn about vaccine efficacy and different strains and all the fun stuff that we're learning about as we deal with the pandemic. Well, so that's all I have for today, but I'm looking forward to the June symposium. And I know we've previously talked about ADA issues, and I'm hoping to really dive into those as part of the presentation that we give for you guys. So anyways, that's all I got.
All right. And last but not least, our friend Hank has rejoined us again this month. Hank is going to be a speaker and a bigwig at the symposium on the business track. So please, folks, make sure that you check him out when you're there. But what do you got for us this month, Hank?
Yeah, good to be back. And sorry again, I missed last month due to a medical issue that didn't let me speak too well or too clearly. But glad to be back on the mend and firing on all cylinders again. Not a ton to talk about. I know that the industry, the market is still super brisk and business is very strong. The last batch of saber rattling that's been going on with the Biden administration, of course, I've seen sporadic pickups in business interest across the country. It's not just in pockets. It's pretty widespread, but I am hearing varying degrees of kind of the why behind why people are coming in based on the recent administration's saber rattling. But the biggest thing I do want to bring to the audience, and I'll even elaborate a little more based on some feedback from the last session earlier today. The first one thing that I'm seeing for the first time in a year is retailers selling ammo by the case, particularly specifically 9mm ammunition, and in some cases 223, and in one case 45 ACP. Though I don't know where on earth they got that. But the one I want to focus on is 9mm. Seeing case lot availability for the first time in a year always, to me, waves a quick red flag as to, are we approaching some sort of demand supply crossover point, or is it just that Turkey is shipping so much ammo into the country right now that they're filling the void and filling that gap? I can say without question, the number of retailers that I've talked with that over the last year have gotten import licenses to self-import ammunition themselves has gone through the roof. I've never seen so many in the past. And they're bringing in container quantities of ammunition, and it seems that they're, it's high price, it's off-brand kind of stuff, so it's not your major U.S. manufacturer, tried and true brands. But again, seeing that for the first time, retailers selling 9mm by the case in that $700, $800, in some cases slightly above $800 price range per case is if we compare that to the past and ammo unobtainium cycles like we're in right now, that is a good indicator to me that I'd be double checking my outstanding orders and saying, where do I sit? Where am I at? Now, based on some feedback from folks in the last session saying, hey, I'm still struggling to get ammunition, 9mm or whatever. I will say that in the 30 plus years I've been in this industry, yeah, when product gets thin, vendors, will play a little bit of favoritism on older, more reliable accounts that they've had a relationship with, say, for 20 years or whatever. But I have never seen it stronger than this past year of some retailers are getting fed and fed well, and some retailers are not getting fed very much. Well, maybe enough to kind of keep them on the taste, but not getting huge quantities. And when I say huge quantities, I'm talking about, million round shipments of ammunition to retailers. That's the kind of thing where it seems like it's a feast or famine situation. I see some retailers or talk to them through either face-to-face or secondary channels, and it's like, oh yeah, we just got a shipment of 1 million rounds in or 2 million rounds in. But again, the thing that I would just caution everyone to is start looking at what is the the horizon looking like for 9mm ammo because of that first sign of, are we hitting a crossover point with particularly import ammo? And again, even more specifically out of Turkey, where just in the last month, I've talked with a number of retailers who are talking about container level shipments on the water right now, coming into their shops and, you know, ordering multiple millions of rounds of ammo on these borders. So it's that first kind of, for those that have been around during the Trump slump, you know, these are some of those similar indicators where, and for those that have been around a while, this industry has a history of hard charging and then the brakes slam on and not even have anti-lock brakes on it, but just slam on really hard. And one month you're selling everything you've got, and the next month, because you know that demand supply crossover occurs and Federal or Winchester, whatever, starts shipping a little bit more reliably, or you're able to get a little bit better quantity than you were prior. And suddenly the off-brand high-priced stuff that you paid 60, 70 cents a round for suddenly gets forgotten by the consumer and their buying preferences goes somewhere else and you get stuck with this stuff. That, again, I'm just taking my 30 years of industry experience and saying, hey, this is the first ammo red flag I've seen yet when it comes to double checking your order levels and making sure that, you know, your risk versus reward isn't in a position where you get in a 2 million round shipment and you end up eating all your cash flow because it's stuck on a big old pile of ammo that gets quickly into the overpriced position once the market pressure normalizes. So that's the big message for me based on what I'm seeing out there.
All right. All right. If anybody, just looking down the side here on the chats to see if anybody sent anything in here. Yes, Paul, you will have the recordings. Just so everybody knows, every Friday the link comes out for the webinars. It comes out every Friday in the solution of the week. And then it is on every Monday's reminder about the email as well. So if you are looking for the links to the webinars, by the time we get them pulled down, scanned through, posted, it's usually not until Friday of this week. Joyce, this is the California seminar. That question that you have is more suited for the help desk. But yes, you do need an import license if you are importing. But go ahead and put that into the help desk, that one. I know there was an answer there for you in the library. Matt and Josh and Chuck, do you have anything else to add before we skedaddle for the next couple weeks? All right, and it looks like our next webinar is going to be on Monday, May 3rd. And just another reminder to everyone about the symposium, please go onto the clients only website. You can get your free tickets in there. And then it is only $50 to add an additional track. Matt, were you trying to get me?
Nope.
Nope. Okay. So please don't forget about the symposium coming in June, and go ahead and take a look online. And we appreciate everyone, and we will see you again on May 3rd.